come forward and you shall be heard. God save the state of West Virginia and this honorable court. Please be seated.
Good morning. On behalf of the court, it's again a distinct pleasure for our court to be here at Marshall University. We appreciate the invitation. The Constitution is a very special document. I think you're going to find some of the cases today to be of great interest in that regard, and I think it's a wonderful thing to have the opportunity to celebrate our nation's Constitution here at Marshall University. I want to thank President Kopp and all the faculty, all the students, and the City of Huntington for their warm hospitality. And also I want to thank counsel for their preparation for this docket. Mr. Perry, would you please call the first case?
First case for argument, State of West Virginia versus John R. Mullins and State versus Linda Sigler, 34584 and 34741.
If it please the court. My name is John Jack Thompson, and I'm from Fayette County, and I'm here today on behalf of the petitioners, John Mullins and Linda Sigler, in a case which challenges the constitutionality, the reasonableness of so-called traffic stops, safety check stops, or administrative roadblocks. It is significant that we come today here at Marshall University and celebrate the Constitution of the United States. An attorney practicing law for 35 years, it came to me about 3 o'clock this morning that sometimes we take for granted the rights that are fundamentally given us in those two documents, the United States Constitution and the West Virginia State Constitution. Those documents are as old as the founding of this nation and the state, and the words have not changed. The law changes as the state and as the nation develops. We are here today to present a set of facts, present a set of circumstances that we believe necessitates law that will govern in the future roadblocks, traffic stops under the guise of administrative roadblocks. This court, spoken previously,
Counselor, you contend that the stops in this instance, you contend that the stops in this instance violated your client's Fourth Amendment rights against search and seizure?
Yes, we do, Your Honor.
And specifically a seizure?
Yes, sir.
That somehow the state, in stopping your clients, crossed a line and violated your client's rights?
Yes, sir.
Do you contend that the state is unable to make stops under any circumstances?
No, sir.
What should be the balancing test for when the state is able to make a stop?
The case of Litzler, Illinois versus Litzler, has a three-prong analysis. And we look at the gravity, the reason for the stop is the gravity of the violation. The second prong of that, Your Honor, is the degree to which the stop advances the public interest. And the third prong of that analysis is the severity of the interference in a stop with an individual citizen's rights. In these particular cases, Your Honor,
Mr. Thompson,
the first case of Mullins,
Mr. Thompson, the facts of these cases, these two cases are different in terms of facts, but the facts are very important here.
Yes, sir.
So would you explain to me what appears to me to be the most egregious situation, the Golly Bridge situation?
Yes, sir. Your Honor, this particular stop occurred in the small town of Golly Bridge in Fayette County. It's a one-lane town. My client, Linda Sigler, was returning home. She was stopped at approximately 3:20 in the morning by the town's sole on-duty policeman. Under testimony at the motion to suppress, the officer testified that he was uncertified, had not been properly trained, that his chief had given him blanket authority to conduct such tests or such roadblocks. That particular roadblock resulted in his parking his cruiser across the main street, activating his blue lights, and then coming out of the vehicle without any safety vest whatsoever and with a flashlight to flag down traffic. The court has spoken with regard to sobriety checkpoints.
Now, as I understand,
Yes, sir.
is it a fact that he did say that he did that solely because he didn't have anything else to do that evening?
Yes, sir, he did. And, yes, sir. And with nothing else to do, this agent of the state took it upon himself to use a cruiser to stop traffic.
Okay. Now, in the case of what Fayetteville or Oak Hill, where the other one was, that had 2 police officers. Is that correct?
Yes, sir. The final arrest was made by 2 police officers.
So what happened in that case?
All right, sir. Earlier in that afternoon, a deputy sheriff decided that he wanted to set up a safety checkpoint in an isolated area of Fayette County near Class 6 Rafting Company, which also has Smokies on the Gorge, which is a restaurant and a bar. Mr. Mullins had left that bar at approximately, or the facility, at approximately 10:20. He was on the unmarked Ames Heights Road when he discerned 2 individuals, again, without safety cones, without safety vests, without auxiliary lighting, without adequate places to pull to the side, 2 individuals' flashlights. As he approached them, he discerned that they were police officers and stopped exactly as he was supposed to have stopped. No suspicion with regard to an expired inspection sticker or expired license plate. That particular stop had started, we understand, at about 4 to 5 o'clock that afternoon when this particular officer went to his commanding officer and said, hey, I want to set up a stop over here at Ames Heights because I have personal experience and know that there are a lot of folks running over there with expired stickers and expired licenses.
Now, as I understand, Fayette County Sheriff's Department had in place a written policy on sobriety checkpoints.
Absolutely detailed and follows the state police policy as contained in Davis or Cart.
Now, Golly Bridge did not have anything.
They neither had written policy with regard to safety checkpoints. They had no policy whatsoever with regards to sobriety checkpoints.
Well, let me ask you, both these people they stopped were drunk.
Your Honor, they smelled alcohol.
Why does that violate the Constitution of the United States or West Virginia?
Yes, sir. That's a good question.
I know it.
50 years ago, the United States Supreme Court in Henry versus United States said it's better. So the Fourth Amendment teaches that the guilty sometimes go free than that citizens be subject to easy arrest.
Well, what you're asking us to do is, if we find a violation of the Fourth Amendment, exclude the evidence.
Yes, sir.
Without that evidence, your clients cannot be convicted of DUI.
Let me back up, Your Honor. With regard to the Mullins case, we're asking that the conviction be set aside because we did go ahead in the magistrate court and he was convicted.
And your contention is that the penalty to the state for doing an improper seizure is the exclusion of the evidence,
Absolutely.
regardless of whether the person was acting in an illegal manner or not.
Absolutely.
And that the issue of sobriety goes to the first prong of the test, which is the state's interest in doing the action that it's doing.
Well, it wasn't sobriety, Your Honor.
What was
It
safety,
was
here?
Yes, sir.
Do you contend that the term safety was simply a pretext here for a sobriety checkpoint?
Justice, we do. There is no proof, but we have reason to believe.
Well, can the state engage in mixed motive stops, where the stop happens to be for safety, but if they see something else?
Yes, sir. If
That's legal under the U.S. Supreme Court's
Yes, sir.
clear on that.
If it follows the more strict standard of written guidelines, a preconceived neutral plan with plenty of safety devices out there.
Well, if the state concedes that on a sobriety checkpoint, there must be certain procedures followed, the vests, the notifications, the alternative routes, et cetera. If the state concedes that, do you contend that the U.S. Supreme Court or any decision of this state has said that on safety checkpoints there needs to be any form of written guidelines, written procedures, training of the officers, or anything else?
Yes, sir, we are. And other jurisdictions in
I'm asking the U.S. Supreme Court or this jurisdiction first.
yes, sir. Under Prowse, the United States Supreme Court said that in that case, Delaware and other states were free to set up procedures with regard to licensing checkpoints. We are asking this court to make it law in West Virginia, to make law that provides for strict, written, neutral, non-discriminatory policy with regard to police officers in safety checkpoints.
I think we've got your side of the argument. Let's hear from the other side.
Yes, sir.
I don't want to cheat, Jack. Good morning, Your Honors, everyone who's in attendance today. First of all, I'd like to thank Marshall University. I'm a graduate from Marshall, so you can go home again. My name is Brian Parsons. I'm an assistant prosecuting attorney in Fayette County, West Virginia. I work for Carl L. Harris, our elected prosecutor, and I practice in front of Judge John W. Hatcher, Jr., who has one of these cases, and Judge Paul M. Blake, Jr., who has the other one. So I've got to really watch my P's and Q's today.
Mr. Parsons, at the outset here, one of the things that we're talking about is search and seizure and the stopping of a citizen who's going about their business. Now, you would concede that the state is unable to do that absent some special reason or some balancing test, some probable cause, something such as that.
Absolutely.
There's a balancing test,
Absolutely,
correct?
Your Honor.
Let me ask you then, how is the interference to a citizen engaging in their normal pursuits of life any different on a sobriety checkpoint than it is on a safety checkpoint?
Well,
I mean, they're still being stopped, aren't they?
Well,
answer my question, then you can explain.
Well, no, let me address that. I think that's the key to this whole case. And if you look at the Prowse case, which I think is really the first case in the Supreme Court to deal with this issue, obviously the majority opinion is the controlling authority here, but Justice Rehnquist's dissent, I think, encapsulates my argument and my response to you, sir. And what Justice Rehnquist said was that there's two important things here.
You're
One,
wanting us to follow the dissent in Prowse?
yes, well, Your Honor, it encapsulates my argument.
Why wouldn't we follow the latest United States Supreme Court in 2000, Indianapolis versus Edmonds, where it said on all stops you have to have narrow, predetermined written guidelines, and you had none.
Well, in one case we did, Your Honor.
You had sobriety guidelines,
Yes.
but this wasn't a sobriety stop. This was an administrative safety checkpoint.
Yes, Your Honor,
And
that's
you had
correct.
no guidelines for that.
For neither jurisdiction.
So
no,
why
sir.
should we follow the dissent in Prowse and not follow the majority opinion in the latest case in 2000?
This is why, Your Honor. If you look at the situation in which we find ourselves, you're asking the state to ensure the safety of motorists on the public highways. We can do this one of two ways. We can be preventative or we can be reactive.
We're asking you to ensure the safety of the motorist on highways?
I think that's a police powers job of the state.
I think that is a...
How's that any different than having a police officer come into my house or a fire official, the state, come into my house to check for fire issues?
Well, it's different for two reasons. One, you don't require a license and there aren't restrictions on your ability to own a house.
Okay, well, how about what stops campus police from going into dorms here at Marshall University to look for hot plates?
Because there's a difference between a residence and a person's privilege to operate a motor vehicle on a
Person
public
doesn't have a
highway.
privilege, doesn't have a right to go to college.
And you talk about safety, that you did it for safety reasons, a safety checkpoint. This is in the middle of the night. There were no visible cruisers. There were no flashing lights. There were no warning signs. You just had a couple cowboys out there waving lights that didn't even have vests on. They're not going to stop me.
Your Honor,
I mean, the police officers, we need them, and they want the citizens to obey the law. But they have to obey the law too. And you had no predetermined operational guidelines. Safety my foot. They hid the cruiser, didn't even put the lights on so citizens would know they're going to be stopped. They're not interested in safety.
So I go back to my question. If you're driving down the road and you're stopped for your safety checkpoint, to me, how is that any different than if I get stopped for a sobriety checkpoint? I'm being stopped by the state. my freedom is being intruded upon, regardless of what I may be doing. The stop is still the same. The impact is still the same, isn't it?
It is.
I mean,
but
you want to look at it from the state's interest side, but I think because of the Constitution, we have to look first at the impact on the citizen, and then we look at the balancing factors.
And I agree,
here I
Your
would
Honor.
contend to you that the interest of the citizen is the same regardless of what kind of checkpoint the police might want to have.
And it would be incorrect if the justices have the opinion that, that the state is unconcerned with the citizens' right to be free from unreasonable searches and seizures.
And you're right. The state has certain interests. The state has interests in keeping drunk drivers off roads. And that might be right here. The state might have an even greater interest in terrorism. My question to you, though, is safety. You're saying something that's in a very generic term, safety checkpoints. Well, I've got to be honest with you. That's not anywhere close to the interest in terrorism. That's nowhere, I don't think, close to keeping drunk drivers who are imminent threats off the road. It's something back here. And if we require, by law, certain requirements for sobriety checkpoints, why should those not apply to something that's even less of an interest of the state?
Well, with all due respect, I disagree, Your Honor, and here is why. If the licensing requirements that our Department of Motor Vehicles and our legislature promulgates, if they mean anything, if a licensed driver...
Licensing requirement is an administrative function.
I understand, Your Honor, but if we are to assume that in order to be a safe driver on our motoring highways, you should be licensed, okay? If we are to assume that that's an important interest, if we are to assume that having insurance on a vehicle is an important thing, in terms of...
I don't think we're saying they're not, but those aren't imminent threats to people driving on the highway.
Well, I disagree.
Unless you're contending that whether or not a car has insurance is somehow equivalent to somebody who blows a .17 on a breathalyzer. Because if that's your contention, I'm not really going to buy it.
Well, Your Honor, if it's unnecessary to worry about whether drivers are licensed or not, then why do we have all these rules?
I'm not saying it's not, but that doesn't give, I mean, that
You
doesn't
can't
give the
stop
police the
somebody
right to
without
stop
reasonable
everybody.
suspicion, unless, as the United States Supreme Court said, you had no reasonable suspicion to stop anybody out on that lonely road, unless you have narrow, predetermined operational guidelines under the latest United States Supreme Court case. Now, why shouldn't the police follow the law, too?
Well, Your Honor, candidly, under State versus Davis, a 1995 case...
And Indianapolis versus Edmonds is a United States Supreme Court case that takes precedent in 2000, 5 years later.
And was State v. Davis an authored opinion?
It was per curiam.
It was per curiam, Your
So
Honor.
what precedential value does it have?
Well, Your Honor, it's what we relied on at the court below.
And State v. Davis is... Justice Fox, 4 months before, wrote a detailed opinion and said you had to have predetermined guidelines, and then this per curiam that nobody signed was written, and we're supposed to overrule Judge Fox?
Well, you put the state in this situation, Your Honors. If you take away any sort of ability to do safety checkpoints.
Well, we're not saying that. We're not saying that. No court has done that. What we're saying is, it goes back to the three-pronged test. The interest of the state is on one side. The interest of the citizen is on the other side. The interest of the citizen is always heavily weighted. That's what our Bill of Rights is all about. For the state's interest to override, not only must it rise to a certain level, but it also must be joined with certain administrative guidelines, the vests, procedures, training. How many safety professionals were out there, car technicians, automobile specialists were out there with these police officers? If these were true safety checkpoints, why don't you do it like they do for truckers? And when they're pulled over, actually have a mechanic there to check. Was there one? I don't think so. That makes it look like pretext. It looks like this was an attempt to get around a sobriety requirement by simply calling it a different name. How many... And so let me ask the question, how many safety infractions were cited to people who were not otherwise cited also for DUI?
Your Honor, I have no idea. In Gully Bridge, none. At the county checkpoint, I don't know, Your Honor.
Mr. Parsons, would it be fair to, would you concede that the Sigler case is less defensible than the other case?
Your Honor, I feel like I'm in a very conceding mood right now anyway, but I feel like the bull that got invited to the bullfight right now. But no, listen, I'll just be honest with you. The Gully Bridge case, the problem with the Gully Bridge case from my perspective is we got a third offense DUI. I know that we don't look for result-oriented cases necessarily, but I'm the city prosecutor in Gully Bridge, okay? And here are the choices in Gully Bridge. Would I rather have the police officer at the Gomar drinking coffee or out being proactive and doing something? The case is not as defensible as the county case. I do concede that. However, the consequences of the police activity are very grave. And if I didn't want to try to keep that conviction, I wouldn't be arguing and quarreling with you all day.
Well, is it true, in that case, did not the trial judge say that random stops are permissible?
Yes, yeah.
And so, but you wouldn't concede that that was appropriate in this constitutional context, would you? Random stops?
Well, I think that you have two different things happening with the randomness. If you come up with a preconceived plan, which seems to be the way most courts seem to be going, then I think you start to inject into this sort of a targeting police response that I don't really think is acceptable. The randomness of it is what I personally like about it. Instead of saying, let's go sit up in Fayetteville and we're going to catch, every lawyer leaving municipal court at 6 o'clock, there's something to be said for the randomness of it. I think in some ways the more random it is, the less discriminatory
then let me follow that up with, what case has ever agreed that random stops are permissible?
Well, as I said, the courts all over the country seem to like it not to be random. They seem to like it to be pre-planned, preconceived.
Well, and that's my question. Which courts have really authorized random stops?
None.
Okay.
None.
I mean, the citizens have rights. And you cannot stop a citizen unless you have reasonable suspicion of a crime. And so you have this guy go out at 4 o'clock in the morning on a lonely country highway on his own and sets up a roadblock for no reason at all. And when I read it, frankly, I thought, boy, it's a good way to meet women. Well, why else would he be out there 4 o'clock in the morning on his own?
Officer Burkhamer is married with 2 children. He's a fine fellow, Your Honor.
Well,
The fact of the matter is you got 3 people who were intoxicated off the road that night, right?
True.
Now, can you give us any type of administrative framework other than the balancing tests that the U.S. Supreme Court, I mean, the fact that the U.S. Supreme Court has set forth certain requirements, the fact that other courts have looked at having certain procedures in place, can you give us an alternative to that that would be constitutionally permissible?
Your Honor, I think that if I could go to the Fayette County case, and I have the utmost respect for Mr. Thompson, we're tickled to get to do what we do here in front of you all today, because we get tired of Judge Hatcher and Judge Blake all the time. But
we don't like them.
The Fayette County case, the actual complaint they received is that there were people running up and down this road without licenses. And I can tell you as a prosecutor for the last 9 years, my goodness gracious, 30% of the cases we have in court, the first square root is they don't have a license. So the police officers out there trying to check something that's inherently difficult to check unless you pull them over for some other offense. So I think that the way the county did it in terms of identifying a need, a criminal investigatory need, should be the first step. The second step should be to set up a checkpoint that is minimally intrusive and, as Mr. Thompson said, is safe not only for the police officers but for the motorists who are coming through it. And then the final checkpoint, or the final issue, should be, are these being conducted in a way that is not putting upon these people and is fair? It doesn't cause them anxiety or what have you. I think That is a very doable solution. I would hate to.
Isn't that exactly what Judge Fox wrote in Cart versus Klein? You've almost identified verbatim his three-pronged test.
Yes, ma'am. The difference in the Klein case is that was a DUI checkpoint.
I understand that, but again, going back to one of Justice Benjamin's questions, why should we have two different standards? I mean, it seems to me that
I'm sorry.
it seems to me that that's a burden on our law enforcement. If we have the same standard for either type of check, it makes it really easy for the police and very understandable for the public.
And I agree with you in part, but let me say this. I think that the law is behind technology in this respect. When DUI checkpoints first came out, and I have no empirical data, just talking to police officers, they had a lot of traffic come through them because we didn't have a cell phone in every car. We didn't have text messaging. We didn't have all these ways to foil these DUI checkpoints. Now technology has changed, and I think that the DUI sobriety checkpoint standard is too burdensome to accomplish the law enforcement objective that we all agree is important.
But while that's the obligation of the executive branch, it's the obligation of the judiciary to protect the overreaching of the executive branch and to protect the citizens' rights, and that's what we're required to do here. And the intrusion, I would submit to you, is the same whether it's a police checkpoint for sobriety or a police checkpoint for checking licenses or a police checkpoint for checking insurance. The stoppage is the same and the intrusion into the person's life is the same. And that's why we have to do the balancing.
Yeah.
Of course, there's a big intrusion if you get killed by a drunk driver, too.
Yes, ma'am.
How big are your different police departments here?
Our largest municipality is Oak Hill. We have 12 police officers.
Probably don't get a lot of money for training and much less mechanics being out there with you.
No, ma'am.
Yeah.
And the county sheriff's department is supposed to be manned with about 30 deputies, but typically it's around 20 to 25. And then it drops off from there in terms of equipment, training, and manpower. But if I could just take that and answer your question, I agree, and I have no quarrel with the need to be minimally intrusive on the citizens' rights. However, I think it's important for this court to note that in protecting the citizens' rights, it doesn't do us one bit of good to go find that a driver didn't have a license or wasn't insured or was intoxicated after a wreck. And in Justice Rehnquist's dissenting opinion, that's exactly what he said. It gives you little solace for us to go clean the mess up after it happens when we have an opportunity here with proper rules properly implemented to be preventative and not just reactive.
Well, but the problem is you had no rules for safety checks,
and you,
roadblocks. You had no rules.
And I think you very well summed up what the ever-present balancing test is between citizens' rights and the needs of government. But Ms. Parsons, thank you. Let's hear
Mr.
back.
Parsons, you had an uphill battle, but you did a good job.
Thank you. Let's hear from the other side. And
It's a pleasure.
thank you.
Thank you, and my remark will be extremely brief. We have a very special day today, and I would like to leave this thought with the court. 70 years ago, the United States Supreme Court in Byers versus U.S., it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Thank you.
Thank you.
Next
Case
case
will
is
be
for
submitted.
argument, Charleston Town Center versus the West Virginia Human Rights Commission and Stephen and Cynthia Bumpus and August Robinson, number 34739 and 34740.
Thank you.
Please proceed.
Good morning, Your Honors, Counsel. I'd like to first say, as with the last council, what a great pleasure it is to be back at my alma mater as well, and what a wonderful opportunity this is, not only for Marshall, but for the Huntington community to be able to see the workings of the Supreme Court
Are you
firsthand.
guys trying to get my vote? Because I'm the only Marshall guy up here.
I can only speak for myself, and I can tell you I am not, Your Honor, but I will take whatever I can get. May it please the Court, my name is Kevin Levine. I'm here today with Ann Haight. We're from K. Casto and Cheney in Charleston. We represent the appellant in this matter, the Charleston Town Center, in this consolidated appeal of two adverse Human Rights Commission's rulings that found in favor of Kevin Streets and Stephen Bumpus. Your Honors, the issue in this matter, if I can just kind of cut to the chase, is really a very simple issue. Whether a shopping center's enforcement of its code of conduct as to a group of juveniles rises to the level of racial profiling or discrimination simply because those individuals are African American. The Town Center argues that it does not, and further argues, more specific to this appeal, that the record in this matter is full of examples of instances in which the ALJ's factual findings and ultimately the Human Rights Commission's affirmation of those findings were clearly wrong in light of the reliable, probative, and substantial evidence on the record as a whole.
Well, was there any evidence, though, that these juveniles were doing anything to act rowdy or, bothering anybody or anything?
Well, there was, Your Honor, and there was ample evidence on the record as a whole.
Specify what that was, because I didn't see that.
Certainly. For instance, probably the most specific would be this was Exhibit 17 and 22. These were the Town Center Security Daily Activity Records. Again, going all the way from, it included evidence from all 6 security guards who were on duty that evening, Your Honor. Contrary to testimony at the public hearing, those records not only show the behavior, but they also show that, with all due respect to the appellees, the testimony that was provided was inaccurate. Those records specifically show that there were six security guards who were on duty at the time that the appellees entered the town center, and that they were spread throughout not only the mall, but the garage areas as well.
But you still didn't tell me, what did the juveniles do?
I'm sorry, Your Honor.
That acted rowdy or annoyed people or scared people?
Yes, Your Honor. There are actually three violations of the Code of Conduct when they were in the food court, Your Honor, which is up on the 3rd floor of the town center, as Your Honors probably know.
Well, you refer to this Code of Conduct, and I've seen a copy of that. Now,
Yes.
Where was that posted?
Well, it's actually posted throughout the mall, Your Honor, and it's also available on flyers throughout the mall. And specific to this particular case, it was
Where in
admitted,
the mall are those things? I
They-
mean,
they- I believe
where
there's-
are they located?
Certainly, Your Honor. I believe there was testimony that they were posted around the escalators as one position, and that they were located throughout.
Well, what did they do now to violate the Code of Conduct?
Certainly, Your Honor. Again, there were multiple violations throughout the night. However, the first instance involved 3 violations in the food court itself. They were first of all, they were in a group of 4 or more, which is against the Code of Conduct. They were sitting at tables without food or drink, and they were being noisy.
Just say.
Let's get the third one, though. What's the third
Okay.
one? Making noise?
They were making noise.
Okay.
In fact, Your Honor, I don't mean to interrupt Justice Benjamin, but that's actually what brought the Lieutenant Hager, the responding officer, over to the area to begin with.
You
was
mean
the
there's a
noise.
policy that 4 people or more can't gather in the food court?
Not to the food court specifically, but throughout the mall, Your Honor,
Well,
yes.
you see people eating up there in a group of 4 all the time.
Well,
How could that
I've
be?
been there many times. I've got 5 children.
Well, and Your Honor, there was also testimony in the record that it is conduct driven. In other words, if there is a group of 4 or so, I should say there's a bit of flexibility. In other words, if there's a group of 4 and they're not blocking the pathway, clearly people can get around them. There is a little bit of flexibility there.
I mean, I need to know this in case I need to leave one of my kids home.
I understand, Your Honor.
Well, I want to get back to that Code of Conduct. I have the Code of Conduct here, and I'll ask Mr. Sheridan. I'm trying to find out from you specifically, where is that Code of Conduct? Is it in the record where that document is posted?
I'm sorry.
Yeah, I'm directing you. I'll get to him, Mr. Sheridan. Maybe he can tell me.
Your Honor.
I mean, your argument is premised on a violation of the Code of Conduct.
Yes.
Now, what if I didn't have notice of the Code of Conduct?
There was, and Your Honor, I apologize, I can't point to it right directly, but there was testimony that the Code of Conduct is posted in several conspicuous areas throughout the mall on, I believe, on freestanding signs, and it's also available at the mall office.
Well, let me ask you this then.
Certainly.
If the code of conduct was not visible to one who may fit within the definition under the Human Rights Act, would your premise fail if that person didn't know about that code of conduct?
Well, I don't think, with all due respect, Your Honor, I don't think those are the facts that we're dealing with here.
Well, I know your legal argument, though. I thought your legal argument was based upon the code of conduct.
And that is correct, Your Honor.
So that's my concern. I'm looking at the facts of the situation.
Certainly.
Then I'll apply the law to it. But I'm trying to figure that out, and I went back and got that. And that's why when I heard you stating, I'm just trying to figure this out, as I understand it, the reason they were told to leave the mall was because they violated the code of conduct. Is that correct? Is that correct?
That is correct.
Okay. And if they didn't have knowledge of the code of conduct, then what?
Well, I would agree to answer your question. If it is a fairness principle, you are correct, Your Honor, and obviously there has to be posted notice of those rules. However, again, in this matter, I believe the record as a whole, not just to go a step further, not only was there testimony that as to the location of those, but the code of conduct on its face specifically says, and I know I'm jumping ahead a little bit to the removal issue, but it specifically says violators will be removed from the property. On its face.
Well, aside from the notice issue, you've got to wonder, I mean, that code of conduct you've described and those alleged violations, those sound like things that can be misused in a discriminatory manner. 4 people can't sit together, you can't make any noise. What was the other one, that you can't sit there unless you are eating?
I would agree, Your Honor. There is potential, and I'm not talking here specifically about the town center, but I'm talking in general, really any rule or law there is potential there.
Do you concede that this raises the issue of accommodation and whether or not there is discrimination in accommodations?
I do not, Your Honor.
Do you contend that you have to, if a person goes to, the town center mall, if the person goes to Pullman Square, do you contend that the person who is window shopping is not subject to an accommodation?
No, that's not but I would agree that in that instance they are permitted an accommodation.
Okay.
However,
now the town center mall has a lot of, you'd concede a lot of benches, a lot of areas where people can just sit. They have power walkers who walk the mall. Are those people part of an accommodation?
Well, the critical issue there, Your Honor, is that assuming that those people are not breaking the code of conduct, and again, assuming that it is being applied in a racially neutral manner, they are, you are correct, sir, they are invitees.
So why do they have to be purchasing food to be able to avail themselves of this accommodation, which I think had some public tax dollars that we used to help procure it?
I guess looking at the enormity, looking at the entirety, I should say, certainly it's difficult to find that they were trying to avail themselves of the accommodation when they admitted that they didn't make any purchases, when they essentially were there for social interaction and then broke the rules when they were there.
But the senior citizen, I'm speaking to accommodation right now.
Yes.
The senior citizen who goes there to walk, that's, I mean, are you going to tell those people that they have to leave on that prong alone? Because under your thing, you say they violated 3. If they violate 1, you have the right to throw them out.
Yes, sir.
So what about the senior citizen who's walking?
Well, again, assuming that there's no violation of a code of conduct, and again, tempering that with that bit of flexibility that was testified to, assuming that they are being peaceably walking throughout the mall,
okay,
they're not.
Now let me move to another point.
Certainly.
With respect to these individuals, they were in the food court. The security officer came. Would you contend that when he had the initial conversation with them, that constituted at the latest notice to these individuals that there was a code of conduct?
I would not, Your Honor, and the reason being because of the testimony as to the posting of the code of conduct through the mall. And if I may, too, the record on the whole, and actually I have about 6 or 7 instances here that just turning back to an evidentiary standpoint, to where the ALJ initially ignored these instances, and ultimately the commission ignored the record on the whole, which showed an even handling of the code of conduct. In fact, probably most remarkably there was a perfect example on that very night, April 22nd, 2006, of equal application of the code of conduct. In fact, one of the appellees' arguments in this is that when they were on the sidewalk outside, white people were allowed to go back in the mall while they, ostensibly because they're African American, were not allowed to go back in the mall. Well, there was a specific instance in the record before the ALJ and before the commission to where there was a group, 2 white females and 1 African American female who wanted to go back in the mall. They were specifically not permitted to go back in the mall, and in fact, the police had to be summoned on the very same night.
Was that the so-called the Chili's incident?
Yes, Your Honor. The Chili's incident involved the appellees in this matter. This was a separate matter. But it was the exact, what I'm getting at is that's evidence of equal application and no racial discrimination, no racial bias in the application of that code of conduct.
What about Officer Coleman's testimony that those he was called upon to evict from the mall commonly were black?
Well, first of all, there was some, I don't mean to mix things here, Your Honor, but I think I can maybe kill 2 birds with 1 stone here. And I believe Officer Coleman also testified that he did not respond to all instances at the mall, and there was other testimony from other officers that contradicted that. But
what about Officer Brown testified that all of the individuals he was called upon to evict from the mall over a period of several years were black?
Officer Brown also testified later.
These officers were only called out when there were black individuals to be removed from the mall?
Well, no, I don't think that's, with all due respect, I don't think that's completely accurate.
I mean, I'm being
Officer
facetious
Brown,
to some extent, but at the same time.
I understand your position, Your Honor.
Did you put in evidence from police officers that they were called out to evict other individuals from the mall?
Well, Officer Brown also testified that to his knowledge, that other police officers had been called out to calls of all races. And again, I want to go back just real briefly here. Officer Coleman, his testimony was actually, or his credibility, I should say, there's question of his credibility on the record, which was ignored. And as that example, Stephen Bumpus and Lieutenant Hager both testified that Officer Coleman escorted the appellees from the mall during that encounter around closing time. However, Officer Coleman, when he was on the stand, denied it. However, the ALJ and the Human Rights Commission only held that against the town center as far as the credibility issue, Lieutenant Hager specifically. They did not hold that against Mr. Bumpus. And in fact, in Mr. Bumpus, or I'm sorry, in that fact was actually corroborated by Cynthia Bumpus, who testified that her son had told her Officer Coleman was there. So again, that goes to a credibility issue with Officer Coleman.
You know, the need of the mall to have a safe environment for its patrons is certainly understandable. But I'm going to try one more time. Is there anything in this record that demonstrates these appellees engaged in any conduct, aside from being together in a group, that was threatening or in any way bad behavior on their part?
Well, there was, Your Honor, and again...
What was it?
Well, if you want to jump to the ultimate issue, they were at the end of the night outside Chili's, outside the altercation, they were ordered specifically to leave.
Well, no, go back to the first part. What did they do inside the mall?
Well, again, they were, the second instance after the food court, on the second floor, they were blocking a hallway. And I should say, Your Honor, at that, they were not excluded from the mall at that point. They were only excluded from the food court. Right. They were permitted freely to move about, which they did. And then later on, around closing time, they were again asked to leave. There was testimony on the record that every time they were approached, they mouthed off, and at that point, it was a progression, Your Honor.
But that was after they were told to leave?
No, Your Honor. The third time they were asked to leave. The second time is when they were on the second floor.
They weren't asked to leave until closing time.
They were not asked to leave until closing time. You're correct.
And then they refused to leave.
They refused to leave. The police were called in.
Okay.
Absolutely.
Okay, then back and on to the Chili's incident.
Certainly. The Chili's incident as well. They were, again, asked to leave by mall security. They did not leave.
Did they not contend they weren't with the rowdy group?
They did
From
contend that,
Chili's.
Your Honor, but even taking that, even assuming arguendo that they were not, and I do believe that that's still a question of fact, but even assuming that, they were ordered by the Charleston police to leave. In fact, they were told specifically, leave or you're going to be arrested, and they still refused.
Let's hear from the other side.
Thank you, Your Honors.
May it please the Court, I'm Paul Sheridan, and I'm here on behalf of the appellees, the West Virginia Human Rights Commission, and the complainants below, Stephen Bumpus and Kevin Streets. And as
Mr. Sheridan, when a police officer tells you to leave or you're going to be arrested, what kind of notice does that give you?
Your Honor, I think of that particular moment as a Rosa Parks moment for Mr. Bumpus and Mr. Streets. They had been followed around and treated unjustly through the course of several hours at the Town Center Mall. They were standing on the street corner having just had a meal in Chili's, come out, they were doing nothing but standing on the street corner waiting for Mrs. Bumpus to come and pick them up.
Rosa Parks was a good one. That was a bus. That was a public transportation.
Right.
This is a private mall.
Well,
isn't it true that these plaintiffs, by their own admission, have been in the mall hanging around thousands of times prior to this? That's what they testified.
They had been there before, that's clear.
No. Doesn't the record say they'd been there thousands of times hanging around?
One of the complainants answered a question to that effect in the affirmative.
And they weren't bothered. Now, so what we're talking about here is not rules and regulations, it's whether or not they were racially profiled. Doesn't the fact that they had been there hanging around thousands of times weigh against the proposition that they were racially profiled?
Your Honor, we have no evidence of what the nature of those circumstances were. For example, we don't know if they were with their parents on prior occasions. We don't know, most importantly, we don't know whether Lieutenant Hager encountered them on prior occasions. So
you mean the police officer from Charleston?
No. Lieutenant Hager is the security guard. And I would point out at this point, the only person who provided any evidence to suggest that there were any violations of any code provisions. I mean, all of it depends on Lieutenant Hager, and I would submit that if you examine the record carefully using traditional techniques for determining what evidence is reliable, the inconsistencies in Lieutenant Hager's testimony are legion, and the administrative law judge used traditional techniques in determining that it was not reliable. To go back to the question, Your Honor, about the arrest.
But go back to my question. What proof is there that the reasons given by the policeman to closely observe these teenagers in the mall was a pretext for racial profiling?
That's a very good question, Your Honor, but let me correct the premise that it was not the policeman.
Well, the security guard.
It was a security guard.
Okay, same difference.
A security guard in particular. Okay. And it's a good question.
And because he closely observed them, didn't kick them out till closing time, why is that a pretext for racial discrimination?
If he merely closely observed them, I would concede that that was not discrimination in and of itself, although it might be an indication of a discriminatory intent, but it would not amount to discrimination if he merely observed. However, the observation started, the Town Center Mall's own regulation, or own records indicate that as early as 7:30, while these, Mr. Bumpus and Mr. Streets were with one companion in a group of 3 traveling through the mall, a security guard made a note that he'd kept black males moving. They were already being profiled before there's even a pretense of any violations. And so that's evidence of motive. Secondly, they were, the credible evidence in the record is that Keith Harris, who was one of their companions, was eating food in the food court when they were there with him. And that Stephen Bumpus had purchased a cookie at Subway.
Well,
now, the records,
I think, Mr. Sheridan, there's a little bit of conflicting testimony on that from the appellees themselves.
There is conflicting testimony, but I think it's very important to recognize that Lieutenant Hager is the only source of the conflict.
Well,
Lieutenant Hager, for example.
If we give to you that you've made a prima facie case out. And it moves then to the town center mall saying, well, all right, but we had a good reason to do this. We had this code of policy, this code of conduct. And then the ball goes back to your court to show, well, that was just pretextual. They were still engaged in some type of inappropriate, unlawful, discriminatory conduct. You can show pretext by direct evidence of some type of statement or admission. Do you have a statement or admission?
We do not have direct evidence of racial motive.
It's never that easy.
You're absolutely right,
Okay.
Your Honor.
Did you put into evidence, because you can also show that by statistical evidence. Did you put into the record any statistical evidence to show that this was pretext?
No, Your Honor. We were unable to do that, and it's very important to recognize that in a situation like this, the respondent holds all the evidentiary cards. We ask them, we ask in discovery for them to tell us about incidents where they'd evicted persons.
You had the opportunity to discover.
And they identified no incidents of any other person who'd ever been evicted.
So does the lack of their ability to, I mean, I want to explore that. They're saying they don't have evidence of that. Does that mean that they're hiding it? I don't want to take an improper tact here. I mean, maybe there isn't.
Well, the two things we ask about that are important here is, one, we ask about incidents where they'd evicted people for violations of the rules. And secondly, we ask about complaints that they'd received from people of racial profiling or discrimination. They said there were none.
Okay.
We found a witness who testified to 3 incidents where she had complained to the manager about racial discrimination.
And that issue was raised with the administrative law judge.
Yes.
Okay.
That's in the record.
Let me also ask you
we have some evidence that their records don't give us.
Okay, so we're not going to get into the statistical. We're now kind of going into a third area that you can show pretext, which is comparative evidence.
We also showed, as you pointed out, based on 2 police officers, one of whom was called by the town center mall, their own testimony indicated that their experience, now it's not statistical, but their own experience suggests that there's a disproportionate tendency to target blacks.
Okay.
I would point out that the appellants in their reply brief indicate that of the eviction orders, the formal eviction orders that the mall does, of those in which race is identified, 45% are African American. So the statistics and the statistics type information available
So your
tends to show
contention
race.
is you have met your burden of showing the pretext, that it's pretextual.
Absolutely. The other evidence.
And what is the standard of review for this court?
The standard review on factual determinations is substantial evidence. If the administrative law judge based his determination on substantial evidence, if he was not clearly wrong, an appellate court should uphold.
What was the evidence of eviction? Because some questions here indicate, and I believe the argument of the other side is that they weren't evicted until closing time. What was the evidence?
Well,
and what was the finding of the hearing examiner?
I think there's an acknowledgement that they were evicted from the food court.
But that's not from the mall.
Yeah, that's right.
Okay.
The issue at the...
And they were evicted from the food court, so people that wanted to buy food would have a place to sit down.
Now, were they evicted from the mall itself?
They were escorted from the mall prior to closing. And the credible evidence, again, it requires looking carefully at the record. Lieutenant Hager claims that it happened after 9 o'clock when the mall was closing. However, he insists that he spoke to Mrs. Bumpus on Stephen Bumpus's cell phone prior to having them evicted. And the phone records were in evidence and indicate that call, the judge goes through a careful analysis of this. Lieutenant Hager's testimony simply does not add up.
Well, was there a record of a call?
There's a record.
What time was that?
No, actually, Lieutenant Hager is mistaken. He never did talk to Mrs. Bumpus. But his insistence upon that it could not have happened as he testified. And
well, what are you saying? There was or was not a call?
There were numerous calls. And this is an important fact. I would suggest that it is completely contrary to normal teenage behavior for a misbehaving teenager in an instance where he's being caught misbehaving to pick up the phone and call his mother. Stephen Bumpus called his mother 3 or 4 times. Each time there was an incident where Lieutenant Hager alleges there was misconduct. So again, it becomes a question of, is it, the real issue here, I think,
what was the evidence that they were evicted prior to closing time?
Their testimony, and the testimony of the sequence of events linked to the phone records. It's really a matter of constructing that.
But isn't that a matter of credibility then between the complainants and the officer, security
Absolutely,
officer?
absolutely. Much of this case.
So, I mean, how can we say that there was no credible evidence for the ALJ to have reached this conclusion?
Well, because it's an issue of credibility between the complainant's testimony and Lieutenant Hager's testimony. Lieutenant Hager is the only person who provided any evidence of misconduct. And his testimony is so undermined by not only the testimony of the complainants, but by the phone records, by the police 911 records, by the police records themselves, by the testimony of Officer Coleman. Lieutenant Hager testified that the first police officer on the scene outside of Chili's was Officer Coleman, that he was the person that engaged Mr. Bumpus and Mr. Streets. He was the person that they abused, and that he was the person that made the decision to make the arrest. Officer Coleman disputed all of those things. He was, in fact, the third or the fourth officer on the scene. He was backup.
When does Officer Coleman's record show that he got there? Police records should show that.
They do, in fact. He was
What does it show?
the third or the fourth officer on the scene.
And what does it show? What time did he get there?
Your Honor, I can't recall. I think it was
Is it in the record?
3 or 4. It is in the record. All that information.
Do you
3 or 4
recall if it
minutes.
was before or after closing time?
Oh, well after closing time. He got, this is at the end of the day. It was at 10-something. This is after the Chili's incident.
Okay.
The important point here is that Lieutenant Hager fabricated or misremembered the events at the end of the day so profoundly that Officer Coleman, it was Officer Coleman's show. Now, Officer Coleman disputes that. Officer Midkiff disputes that. And Mr. Bumpus and Mr. Streets dispute that. And Officer Ross's records from the incident dispute that. Lieutenant
Was
Hager.
there evidence that they were, the other side claims they were blocking people's path and so forth?
Absolutely no evidence of that.
Any evidence of any bad conduct?
Nothing other than Lieutenant Hager's testimony. Lieutenant Hager,
What did he say they did?
starting at the food court incident, Lieutenant Hager testified that he came out of a restroom on the 3rd floor and saw the complainants and went over to them. However, the discovery from the manager of the mall, who conducted the investigation when the complaints were filed, provided information that said that Lieutenant Hager responded to a complaint from a vendor, and Lieutenant Hager could not reconcile those things. Clearly, there were two contrary versions of what caused the incident. Lieutenant Hager also indicated at one point in his testimony that he radioed to the other security guards before engaging the boys in the food court for the first time, which suggests that he was already primed for a confrontation before he even spoke to them. His testimony is that what he usually did when he found juveniles who were in large groups or were in the food court, he would go over to them and he would explain to them the rules, which is what, in fact, the written code of conduct says that they should do. He does not deny that in this case, he made no attempt to explain to these individuals what the code of conduct is.
Doesn't he say he was being ridiculed and so on, and that had something to do with whether or not he explained it?
He does say that.
He says they were calling him names. And that excused him for not doing what he normally would do.
I think what we have...
Just to be fair to the office.
Yes, that's what he says.
Whether that's true or not is a credibility issue.
However, when asked about his usual conduct with regard to juveniles, he was very clear. He said, when I approached them, talking about other groups of juveniles, they usually get upset, he says, until I explain to them the code of conduct. And so if we take his testimony, take that testimony as being true, if in fact that's the way he treats other people, he understands that he's going to get some resistance and he needs to explain. It's a way of applying the rules. And
Have there been any other complaints against this officer? Any other written complaints that you produced into evidence?
None that we have been provided with. We asked that question.
That's not my question.
No.
Did you ask in discovery?
Absolutely.
And what was the answer that was provided? There are none?
That's correct. And we know that to be not factual because we found one person who had made a complaint.
And so you think that we, under the standard of care you talked about, can overrule Judge Wilson's finding of fact that the mall was closed at the time they were evicted and they were refusing to leave? How can we overrule the judge's findings under the standard that you gave us? On page 12 of his decision, he said, quote, "And the mall was closed at this time, and they were refusing to leave." So how can we, using your standard, overrule him?
I may be misrecalling this, Judge, but I think the mall was closed at the time of the Chili's incident. Page 12, which paragraph?
I just got page 12.
I believe, Your Honor, that probably refers to the Chili's incident.
Well, what's our standard again of review?
The standard of review is substantial evidence. If the administrative law judge's factual determinations are supported by substantial evidence in the record.
Well, if he's so found, don't you concede that if he's so found, and you and I both go back and look, but if he's so found, don't you concede that that finding would be supported by substantial evidence?
I think I would, Your Honor. I think that we wouldn't contend that the mall was open at 10:40 at night.
What you're contending is that the arrest that ultimately resulted came about as a result of ongoing discriminatory behavior.
Absolutely.
And it culminated in an arrest by the state at the request of the private party.
Absolutely. And just to go back to the question you'd asked me earlier, Your Honor, it was at the request. It was, but what the mall did.
That goes back to my earlier question to the other side about accommodation. If this is an accommodation, it's a little different than just pure private property.
Right. And our position is that the mall extends to the general public the right to stand on the sidewalk after you come out of Chili's. And that's an invitation that exists to everyone. They had to remove that invitation to make Mr. Bumpus and Mr. Streets into trespassers. And when they removed that invitation, they became trespassers.
Let's hear back from the other side.
Thank you, Your Honor.
Your Honors, I have just a few final moments here. I did want to address the statistical question that you posed, though.
Well, there's three ways to show pretext. If they concede that they don't have any direct evidence, they can show it by comparative evidence or by statistical evidence.
Yes, Your Honor.
Now, they contend that they've put into the record certain information about prior complaints and so on that were not produced in discovery. Go ahead and comment first about comparative, and then I want to ask you about the discovery responses.
Well, certainly, Your Honor. And actually, just in terms of the statistical evidence, and we actually alluded to this in our reply brief, the fact that and I believe it was Exhibit 27, which shows individuals who were banned from the mall from 1997 through 2007, there were actually 120 individuals who and we're talking banned from the mall for various incidents there. Those documents, which were on the record, which were before the ALJ and that were before the Human Rights Commission on the appeal, they show that there were 120 individuals in that period of time who were banned from the mall. And race was rarely noted on those, showing in and of itself that it was not being applied in a racially motivated way. But the 20 times in which that race was indicated, of those, 11 times were showing that the individual who was banned was white, and 9 times they were African American. So again, it shows that enforcement is based on conduct, not on race. And again, those were statistics that were provided by the mall.
You're wanting us to be a finder of fact, and we're a court of appeal.
Well, no, what I'm saying, Your Honor, is these were matters that were on the record before, clearly before the ALJ, they were before the commission. And
your argument is that the evidence that is in the record does not show from a statistical standpoint pretext.
Correct, Your Honor. And
what about the evidence that they put forth by the police officers that with respect to this individual or whatever who said they had made complaints on a racial basis? Respond to that.
Well, again, as I mentioned earlier, Officer Coleman's testimony was actually called into question. Basically by the testimony of Stephen Bumpus himself and his mother and Lieutenant Hager. However, in this matter, unfortunately, the ALJ and the commission, in affirming his holdings, only held that out against the town center. Did not apply that to the credibility of the other witnesses. Just going back.
Let me ask you a question about your brief.
Certainly.
You're the appellant, right?
That is correct, sir.
I was reading your brief. I thought there was something in there that wasn't right. It's on page 14. You said, Judge Wilson based his findings on the determination that the police officers acted as the mall's agent. And so I went back to his findings, and he never found that the police officers acted as the mall's agents.
Well, and actually, that is an issue that Mr. Sheridan did bring up in the reply brief, and we addressed that in the appellant's brief. We actually addressed that in our reply brief, Your Honor, and no, although he did not specifically call them quote-unquote agents.
Well, no, wait a minute. Your brief said he did specifically find and base his determination that the police officers acted as the mall's agents. That's what your brief said.
With all due respect, Your Honor, if that's what it says, that...
Well, let me quote it to you.
Sir.
Judge Wilson based his findings on his determination that the police officers acted as the mall's agent. Final decision at page 29, you quote, per your brief at page 14.
And I'm sorry, Your Honor, is that our reply brief, or is that our appellant's
That's your
brief?
appellant's brief.
Okay, in our reply brief, Your Honor, we expanded on that in response to Mr. Sheridan's comment.
Did you say in your reply brief you were wrong?
Well, we didn't. We explained that. We still feel that the ALJ did consider the police officers agents because he specifically used the words utilized the police department. And just looking at the plain language, the term utilization strongly suggests that he considered them to be agents.
Well, why didn't you put that in your appellant's brief? Because here's what you said in your reply brief. You just did the opposite. However, although Judge Wilson may never have specifically called the police officer agents, his ruling indicates that he may have considered them to be acting in some form of agency capacity.
Well, again, Your Honor,
You know, it's pretty hard when you guys cite a proposition, we got to look it up and it's wrong. And then you say, well, maybe it wasn't wrong. And you know what? He didn't indicate it either, because let me read you the law in State versus Phillips. A police officer acting within the scope of his official duties, making an arrest, acts in his official capacity, and not as the agent of a private employer.
I understand, Your Honor.
But yet you put that in the brief, and we got to contend with it.
Well, and I apologize for that. Again, it's a situation where, when it was brought to our attention by Mr. Sheridan, we did take that opportunity to clarify that position.
What was the charge they were arrested for?
They were actually two separate charges, Your Honor, criminal trespass and obstructing an officer.
Okay.
Just to kind of sum things up, because there are a couple points here that I think are important. Again, we would argue that this case, even though Kmart has come up, the Kmart versus Human Rights Commission case has come up repeatedly, largely in the amicus or the amici briefs that have been filed in this matter, we argue that actually the court can dispose of this case more appropriately under the Cobb versus West Virginia Human Rights Commission case, because that's a situation in which you had a more analogous set of facts. There was there's discipline being imposed on a racial minority. Again, coming back to the facts of this case,
in that case, I think it was pretty egregious. And this was the student case, isn't it?
Yes, sir.
Student indeed had knocked the wig off of a teacher who was being treated for, undergoing chemotherapy treatment.
Yes, sir.
There was pretty egregious misconduct by the student in that case. I'm not sure you've made that showing in this case.
Okay.
So I think we've got it. I appreciate counsel's efforts here. You were very well prepared, and the case will be submitted
Thank you,
for
Your Honor.
consideration. Thank you.
Have a good day.
Next case for argument, State of West Virginia versus Michael E. Martin, number 34709.
Please proceed.
Morning, Your Honors. If there is one principle that's crystal clear about trial evidence, it is that no witness is allowed to express his or her opinion about the truthfulness of another witness in that case, and no witness is allowed to express his or her opinion about the guilt or innocence of the defendant. And unfortunately, that is exactly what was admitted over objection in this particular case. To avoid any ambiguity, let me just read exactly what the testimony was, beginning with a question by the prosecutor of Captain Van Meter.
Captain Van Meter was the state trooper in charge of the investigation that sat at the prosecutor's table during trial.
That is correct.
Okay. So this is what the questioning was to the head investigating state trooper.
That's right.
Okay, go ahead.
Was sitting at table and was the next to last witness and the last witness of any significance called by the state at this trial. Question. Now, as to your investigation of this case, and coupled with your 22 years of experience as a law enforcement officer and captain of the state police, from your entire investigation of this case, have you determined Officer Will Reynolds to be credible? Answer, yes. Then there is an objection which is overruled. Next question. And I'm reading from pages 132 and 133 of the testimony in this case. Next question. And based upon your investigation in this case and your years of experience and your present position with the West Virginia State Police, have you also determined Jasminda Gonzalez to be credible and believable as to this case? There's another objection, same ruling. The witness answers, yeah. This goes on even further with Captain Van Meter testifying that he believes that Mr. Martin's role in this case was as the aider and abetter, which is exactly what he was charged with being in this case. Captain Van Meter was also allowed to testify that another state's witness, Timothy Blackburn, had given, I'm sorry, I don't believe Mr. Blackburn was called as a witness. Another witness to some of the events of the evening, Timothy Blackburn, had given a statement which Captain Van Meter then assured the jury was consistent in all respects with the testimony of Ms. Gonzalez and Officer Reynolds.
Now, were there objections to each and every one of these instances?
There were certainly objections to the ones that I read, and if I could direct your attention to page 127 and 128 of Captain Van Meter's testimony, there was not an objection to, hang on for 1 second, there was not an objection to a couple of the questions about Blackburn.
So
those were not objections.
Well, wait just a minute. What, you say there was no objection?
There was no objection to the questions about Blackburn's testimony being consistent. There were objections to all of the testimony about whether or not the testimony of Reynolds was truthful, to whether or not the testimony of Gonzalez was truthful, and there were certainly objections to his testimony that he believed that Mr. Martin was the aider and abetter in this case.
So you think it's error for a judge to allow a state trooper with 22 years' experience to be able to tell the jury which witnesses are lying and which witnesses are truthful?
I believe that is error, yes.
I think we got it. Let's see what the
Well,
prosecutor
he's got some
thinks.
other points, though. Make a couple of your other points.
Okay, if I could just also mention one other thing about that particular issue. The problem here was that this was a case about credibility. The defense here was entrapment, and there were vast differences between the testimony of Reynolds, Officer Reynolds, and Ms. Gonzalez, and the statement of Mr. Martin. And all of them had to do with entrapment.
What about the state's attempt to try to bring this within one of the rules on impeachment of credibility? Okay.
Problem here is the state cited two rules. I believe that they cited they cited two rules. One of them was simply inappropriate. One of them had to do with impeachment by prior convictions. The other one had to do with character evidence. And if you examine the transcript here, no questions were asked about character, no questions were asked about reputation, and in the questions about truthfulness, the state never said, what is Officer Reynolds' reputation for truthfulness? Or what is Ms. Gonzalez's reputation for truthfulness? The state said, based upon your experience, are they telling the truth in this case? So the two rules that were cited by the state just have nothing whatsoever to do with this testimony. This testimony also was extraordinarily harmful because of the differences between Mr. Martin's statement and the witness's statement about the credibility of these officers. The statements differed over who made the first approach with regard to a drug sale, and that's crucial to entrapment. The questions differed over whether there was financial inducement offered, and that's crucial to entrapment. The statements differed over whether Mr. Martin first refused to do it until a greater incentive was offered. That's crucial to entrapment. The statements differed over whether one officer or two officers participated in the negotiations, and that's crucial to entrapment. And the statements differed over whether there was actually an exchange of drugs or money, and that's crucial to entrapment, which is why any question about harmlessness just doesn't apply in this particular situation. It was error, it was harmful, and it requires reversal. Now, if I may move on to some of the other points. With regard to the indictment, I think it is first important to stress what is not in question. First, it is clear that it's perfectly okay for an indictment to charge just one count of murder that contains multiple theories. That's fine, we're not challenging that. In addition, the state doesn't have to elect a theory to proceed on if they don't want to. That's okay, we're not challenging that. In addition, the court is perfectly proper, it's perfectly proper for the court to instruct the jury that they don't even have to be unanimous about one theory of murder.
Okay.
We're not challenging that.
He was indicted felony murder with the underlying felony of drug delivery, correct?
That's correct.
Okay. As I look at this record, though, you knew pretty much before trial that the trial testimony was going to be felony murder with the underlying robbery.
Actually, I was not the trial attorney, but the
Well,
trial attorneys,
I'm going to say you.
the
because
trial
you're-
attorneys in the case were notified sometime shortly before trial that the prosecutor, and I don't know exactly how long before trial, they were notified, I believe verbally, they were told by the prosecutor that the prosecution...
I think it's about 2 months. The record seemed 2 months before
That's fine.
trial.
The prosecutor told the defense and the court that she wished to have the jury instructed on the alternative theory of felony murder in the course of a robbery as well as felony murder in the course of a drug deal.
These four people get into a Jeep, go over to this house. The defendant gets out, goes up initially, makes contact with the shooter, comes back, and then the decedent officer goes over,
Correct.
gets to the bottom of the steps, and he's shot by the...
By Leftwich.
By Leftwich, correct?
Correct.
And so was that the breakdown there in terms of whether it was delivery of drugs or the attempted robbery or not?
First of all, there was no evidence of an attempted robbery. There was no evidence for him to be talking about an attempted robbery. There was just nothing to back that up. So the evidence of that was not only insufficient, it was non-existent. In answer to the first part of your question, the state did tell the court and the defense that they wanted an instruction on that. The problem is, the grand jury made a choice to explicitly indict...
But the courts are split across the country on that issue.
Actually, I do not believe so. What courts are split on is whether or not, if you have a one-count felony murder that simply says killed in the course of a felony, whether or not the trial judge may instruct on different theories. Our point here, and what separates it from all of those disputes, is that when the grand jury makes a conscious decision to choose a theory of felony murder and to write that into the language of the indictment, that's it. The state cannot ask the judge, and the judge is not permitted to charge additional theories. We don't know if the grand jury heard evidence about those theories. We don't know if they rejected evidence. As Justice Cleckley has written many times, you have to look at the language of the indictment. If the grand jury had chosen to file an indictment that said, did cause death in the course of a felony, period, then we wouldn't be raising this issue, because then the trial judge could have instructed on any theory of felony murder that found support in the evidence.
How did it go to the jury then on the verdict form?
I believe that it was just the one count that went on the verdict form. It was just one count of murder.
Of what?
I am not positive. I'd have to go into the record and take a look at it. I believe the verdict form tracked the language of the indictment.
No, it didn't.
I do not have the verdict form.
Count one.
I've got it.
No.
We, the jury, on the issue joined, find the defendant Michael Martin guilty of first-degree murder as charged in count 1. So it didn't mention the indictment.
It didn't mention, but it referred to count 1 of the indictment. I'm sorry.
How does this deviation between the indictment and the instructions in the proof, does State versus Cora help either side on that case?
I'm not sure, Judge. I think...
Have you read it?
I am not familiar with the holding in that case, Judge.
It's our latest case on this point.
Judge, all I can tell you is, Judge, I apologize if I have not found that case.
It's State versus Cora. It was decided last term of court on variances and constructive amendments of indictments.
Well, Judge, I'm not sure if this is as much a variance on constructive amendments.
No, it's either a variance or a constructive amendment.
But what I'm saying is that this is not a variance or a constructive amendment in that the court simply allowed the jury to consider a charge which was never in the indictment in the first place.
Well, and you don't know for sure what the jury here convicted this gentleman, what basis they used, do you?
It's impossible to know that. Nobody knows that.
And I think basically what Cora said, that if the defendant is charged with a crime in an indictment, but the state convicts him of another charge not included in the indictment, then per se error has occurred. So it could be that Cora would apply. We just don't know.
We do not know. The verdict is indeterminate.
Well,
and one of the,
you know, was there an opportunity for the defense counsel here to have asked that that verdict form be set up in such a manner that we would have known upon what basis the jury convicted the gentleman?
There was an extensive argument over whether the robbery theory should even be submitted to the jury. In theory, either side could have requested that a more specific verdict form be outlined. Neither side did, and as the state has pointed out, there's no requirement that the judge do that.
When I realize that a lot of these errors you say are just plain error, but there were a number of instances where no instruction was requested.
That's correct.
By defense counsel.
That's
on
absolutely
any of these
correct.
issues.
Yes. With regard to this, yeah, there were
And no
issues.
404B limiting instruction.
There was no request for the
requested.
404B limiting instruction. The question of whether that is plain error, I think you have to go to what Justice Cluckley defines plain error as and what this court has. First, is it plain? And this is not some arcane part of the law. Everybody knows that a McGinnis instruction has to be given. Second, in this particular case, we can't say that it was some strategy decision by the defense to waive it, because the defense opened by telling the jury they were going to be hearing the McGinnis instruction. And then the court never gave it, and defense counsel simply neglected to ask for it.
Well, you make a very good case on a lot of these points. Maybe we should hear what the state has to say here.
If it please the court, I am Kristen Keller. I'm the prosecuting attorney in Raleigh County representing the appellee, State of West Virginia. Justice Ketchum, in response to a question that you asked of appellant's counsel, it would be the state's response that it is not okay. And it was not okay, and it was stupid of me, the prosecutor, to have asked Captain Van Meter whether or not he thought 2 eyewitnesses to this murder of Corporal Smith were believable.
So you concede error?
I concede error. I do not concede.
It's prejudicial?
Correct, and I can explain why. First of all, and one reason it was stupid is obviously it would not come as any surprise to the jury that Captain Van Meter, who sat with me through trial, believed the state's 2 eyewitnesses, one of whom is a young canine officer present at the, actually Corporal Smith died in his arms. The other reason, this is an example, and a perfect example of what this court stated in Guthrie, was the human fallibility of the participants, which means there will never be an error-free trial and that the Constitution does not require as much.
This went pretty far, though. I mean, a seasoned, tough, smart prosecutor like you, I don't know how you let this, what were you thinking?
I can tell you exactly how. I call it rule dyslexia, when, as counsel said, it's the end of a long and very difficult trial in your opera. And I'm not complaining, it's just the facts. It's 90 minutes of sleep and a lot of caffeine. I miscited the rules. I know the rule. It was stupid. Now I will say why it is harmless. I completely disagree, and I believe the record will show there was no material distinction between the statements of Ms. Gonzalez and Corporal Reynolds and Martin as to his conduct. We would have loved it, the state would have loved it, if Corporal Reynolds had just testified that he saw a narcotics transaction. How easy that would have been for me. We then would have had a cut and dry first-degree murder. The defense is claiming entrapment. Because he claims entrapment, his massive criminal history of predisposition comes in, which the state has to bring in.
But now that you went pretty far afield on too, didn't you?
Absolutely.
I mean, even people saying they'd seen him around and knew there was trouble whenever he was standing on a street corner, and all kinds of things he was maybe charged with but never convicted of. And
Your Honor, I disagree respectfully, and in fact, the state showed remarkable restraint. And if this court will note, trial counsel, an experienced public defender, there were two trial counsels for the defense, one a former prosecutor and public defender, they, quote, applauded the prosecutor for the prosecutor's disclosure and handling of what we call 404B evidence, but it's really not. It's really a hybrid because we have to prove predisposition beyond a reasonable doubt. We gave what the defense referred to as an itemized list, including 172 pages of this guy's, of Martin's criminal history. We not only exercised restraint, and there was no defense objection to the 405 reputation and opinion evidence, which Justice Cleckley says is admissible when character is admissible, but we, in fact, in fact, more than once warned the defense that they were going beyond what the state was trying to introduce, which was narcotics-related criminal activity. Repeatedly, the defense opened up the door to Mr. Martin's general character. Not only did the state not step in, at one point the record will show that the state got up and said, I'm not objecting, but I'm warning defense counsel. One police officer, non-responsibly, when I asked, do you have an opinion as to whether or not, from his personal experience, Martin has a propensity for drug-related crime, one police officer answered non-responsibly, and there was no objection because the defense repeatedly had agreed that Martin's drug-related criminal activity was admissible into evidence. And most compellingly, the defense agreed, that's why the state withdrew its bifurcation motion, that under State v. Miller, once character and conduct evidence comes in under predisposition, that the jury, I believe the phrase is unfettered discretion in Miller, has unfettered discretion to consider that evidence on the issue of mercy and no mercy. Defense agreed because of the defense of entrapment, a whole lot of conduct and character evidence was going to come in. So the state had a lot more it could have introduced. And again, unlike any other 404B, the state under State v. Houston has to prove predisposition beyond a reasonable doubt. That's why it's not straight 404B. If not for the defendant's claim of entrapment, the state would never have shown any of his predisposition evidence. If I could just briefly, I wanted to just say why as to the credibility. Mr. Martin and Ms. Gonzalez never, contrary to what Appellant's reply brief states, never said they saw definitely a drug transaction. Ms. Gonzalez supposed. Martin at one point says he guesses, but he also says he's guessing that Corporal Smith is trying to rob Leftwich. It was Corporal Reynolds who, not helping the state's case of first-degree felony murder, was definite that there was no narcotics transaction. Cora is inapplicable here, State v. Cora, and that is the, I was familiar with it, the beer case. This court also, at the same period of time, decided State v. Kent, which I believe is more applicable here, because State v. Kent makes clear, as does the whole line of cases on felony murder and the statutory language to prove felony murder, which is just the statutory premeditated murder language. State v. Kent emphasizes again by this court that felony murder and any form of felony murder is just another manner and means of committing the crime.
But how can the state, in this particular situation here, where the grand jury specified in the indictment the form of felony murder, how can you go in and have the authority to add to that?
I believe that the appellant just said we don't know what the grand jury heard. We do know what the grand jury heard. The grand jury heard no evidence of robbery because the state had not come upon the evidence of robbery.
Well, so how can you go in as the prosecutor and decide you're going to add to the indictment?
The case law cited in the appellee's brief includes the fact that if evidence of robbery develops even in the middle of a trial, because it's just a manner and means of committing the crime, we're not charging a new crime. It is the manner and means of committing the crime of first-degree murder. And in State v. Cora and in the other cases in which this court has considered, cited by the appellant's brief with State v. Zaks, the question is the state charging a new crime, and is there a different penalty? Well, just at the same time as Cora, this court emphasized again in Kent, and that was the double jeopardy issue as to whether or not if a person was acquitted of one form of murder, that then they could
then
be...
what was your evidence of robbery during the course of this trial?
Well, we started with the premise that if Corporal Reynolds was right, and of course that's a determination for the jury, then there's only two other reasons why Corporal Smith was shot 4 times in the chest and why Martin and his co-defendant Leftwich then fled. First of all, we introduced into evidence that contrary to his claim to police after the killing of the officer, Martin was unemployed. We introduced the fact that, as he admitted in his statement, he had a severe crack cocaine habit. We introduced, without objection, an experienced narcotics officer who talked exactly about how expensive the narcotics habit was. We had the testimony of Ms. Gonzalez and Officer Reynolds that repeatedly, from the first location where Martin hooked up with the undercover officers, where Martin, by his own admission, had been dealing with Leftwich earlier in the night with narcotics, repeatedly Martin wanted the money, demanded the money, asked about the money, asked how much money all of them had. Martin's own statement was, as quoted in the appellant's brief, in terms of, well, proof that there was no legitimate claim of entrapment. His claim was that, that Corporal Smith, he approached Corporal Smith, said, "How much do you want?" Corporal Smith said, $100, and Mr. Martin's line was, "Well, who could pass that up?" It was also
Well,
the
that
test.
doesn't prove, none of those things you just indicated prove robbery.
Well, I haven't gotten to the end, and
Okay.
again, I don't have to prove Martin as an aider and abetter, as the court instructed the jury, and there was no objection to those instructions. Under State v. Fortner and the concerted action principle, I don't have to prove that Martin specifically intended robbery or specifically intended premeditated murder. All I have to prove is the defendant, pursuant to State v. Wade, is participating in the attempt or commission of an enumerated felony, and that can be any, included his own admission to the enumerated felony of delivery of controlled substance, and that a person, in this case Corporal Smith, dies in the course of Martin's attempt to commit that enumerated felony. If he is present, not necessarily with the same criminal intent as this court said in Fortner, but he is present to engage in criminal activity, is present to assist in the design of the direct perpetrator, the drug dealer, the deranged drug dealer, according to the appellant, to whom he led this narcotics officer, then he is responsible under State v. Wade and felony murder for the death of that law enforcement officer. What happens there at the scene is, after repeatedly demanding the money, the testimony was also that at the scene, right across from the stairway that leads up to Leftwich's house, Martin again demands the money from the officer, from Corporal Smith, walks him across, and this is after a series of phone calls, 4:13 a.m. when he takes Corporal Smith's phone and calls Leftwich, just a few seconds of conversation. 4:18 a.m. is the second call that Martin makes there at the scene. The officer down call from Corporal Reynolds is 3 minutes later. There is no explanation other than robbery or premeditated murder for why, if the plan was for Leftwich and Martin to sell Corporal Smith narcotics, why he would walk down the stairs brandishing a .357. And the state proved beyond any doubt that what caused Corporal Smith to display his badge palm up right before Leftwich fired into his chest, and there's no dispute. Martin even testified that he saw the officer display his badge. There is no explanation except for robbery or for first-degree murder. That certainly isn't a drug transaction. Now, right afterwards, and this became interesting, an extremely hostile state's witness, Paul Leftwich, brother of Mr. Leftwich, the appellant's brief has stated that no one, not ever, discussed robbery. That's not true. And this is a Guthrie issue. In the appellee's brief, I did not refer to the testimony of Paul Leftwich. I referred to his statement. And what happened is his statement and the trooper's interpretation of the statement. The judge did not let the trooper testify to that, so we're safe. The trooper's testimony would have been that the pronoun him meant that Martin and Leftwich, right after the murder of Corporal Smith, were in Leftwich's yard arguing about robbing Corporal Smith, but the pronoun was him. The judge stopped us from letting the trooper testify to that, and Paul Leftwich on the witness stand absolutely was saying, nope, I meant that my brother and Martin were in the yard right after I heard the shots, arguing about Martin bringing someone there to rob him meaning Leftwich. Of course, the remainder of Paul Leftwich's typed statement indicates that whatever Leftwich was telling him in many respects was not truthful, since Paul Leftwich, Brother Paul, says that his brother was going outside to buy pop to eat with their seafood at 4 a.m. Nevertheless,
Ms. Keller, I think if you want to summarize.
I will, I'm sorry. Nevertheless, at trial and pursuant to State v. Reed, which this court, I believe in February of '09, decided, the defense at trial said instead of letting the trooper interpret the pronoun him, let the jury have Paul Leftwich's statement and let the jury interpret it. Under Guthrie, considering the evidence of the Paul Leftwich statement in the light most favorable to the state, it was up to the jury, and we must, under Guthrie, interpret the Paul Leftwich statement as saying that the two co-defendants were at the Leftwich home immediately after the murder of Corporal Smith, discussing the robbery of him, Corporal Smith. Thank you, Your Honors.
Thank you.
I have 3 or 4 points I'd like to make. First, with regard to the state's last statement in which they claim that Paul Leftwich said that he overheard Mr. Martin and his brother Thomas Leftwich discussing robbing Officer Smith. That is absolutely incorrect. I went into that in detail in the reply brief. Let me read the testimony. This is the state's question. Question: what was your brother doing? Answer: when I seen him, he was standing outside, and he said that, I can't believe that you brought these white guys over here to rob me. I should shoot you and get out of here and don't ever come back around here no more. That's what he said to Martin. There is no ambiguity. There's nothing to look at in a light most favorable to the state, because Leftwich's testimony and his statement were crystal clear.
Well, that's factual things. Look, the state's conceded error.
Yeah.
Now, the issue now is, was it harmless? Was it harmless?
Let me address that. First, with regard to the error about the opinion testimony on credibility and truth, Reynolds and Gonzalez's testimony was not identical. It differed in numerous ways. It differed over whether they saw an exchange of something. It differed about the time that Officer Smith first attempted to buy drugs. Reynolds testified that he was in contact with him the whole time by the phone. Reynolds didn't think it was going well, so he immediately drove to pick him up. Gonzalez testified.
Well, that's not terribly crucial. Focus on the crucial portions.
The most crucial portions of the differences were, Michael Martin said in his statement that the police first approached him. Officer Reynolds testified that Martin approached them first. That's a crucial difference for entrapment. Martin testified that when they approached him, they asked, "Can you get us drugs?" or something to that effect. The police said Martin was the first one who brought up drugs. That's crucial to entrapment.
You know, this wasn't an entrapment case.
Well, Judge,
when the thing stemmed around, this guy didn't know that guy was going to come down the stairs and shoot him. The defense in this case is you need a little mercy.
Of course.
But it wasn't entrapment.
Well, first of all, of course, Martin didn't know that Leftwich was going to shoot Officer Smith.
There's your defense.
Well, that was one of the defenses
well,
that was
but there wasn't
raised
any
at trial,
evidence of entrapment. This guy, they went there to buy drugs.
Well, one moment. When a charge is made of felony murder in the course of a drug deal, which is the only felony murder the grand jury indicted on, and having listened to the state's argument here, which the state now concedes was the only felony that the grand jury heard evidence of. The state admitted here that the grand jury didn't hear evidence of anything to do with the robbery.
Yeah, but State versus Cora relied upon...
Judge, if I may say something about Cora.
Well, you said you hadn't read it.
Well, Judge, I wish that Mr. Ayers mentioned something to me.
Well, no, let's read the thing before you start telling me about it, because I wrote it.
Judge, if you had referred to that as the beer case, I would have known exactly what you were talking about. That was the case in which the charge was underage sale of beer to a juvenile, sale of beer to an underage person in a bar. And the testimony at trial varied from that. That case I read. I'm sorry I didn't recognize the name of the case, Judge. I should have. But if you would have said the beer case, that I would have known something about it. But based upon great experience. On the other hand, Judge, when you have somebody who's been indicted for felony murder in the course of a drug deal, and the defendant elects to raise a defense of entrapment, the defendant is allowed to put on that case. Mr. Martin's statement went in, which raised enough evidence of entrapment to get a jury instruction, which by definition means that a jury, if it had believed that, would have found that this was entrapment. The problem is that the state was allowed to call two witnesses, qualify them as experts on credibility, to testify that the state's version of those crucial facts about entrapment, who approached whom, who first raised drugs, was there an incentive given,
And
how
that's
was
the
the deal
issue.
followed
Was it
up?
harmless? And you won't tell me why it's harmless.
It is not harmless because Mr. Martin's statement on every one of those factors, who made the first approach, was different from what Reynolds and Gonzalez said. Martin said police made the approach to him. On the issue of who first asked whom about buying drugs, Reynolds and Gonzalez said Mr. Martin was the one who came up and said, I can get you drugs. Mr. Martin's statement, in effect, said, they came up to me and asked if I could get drugs for them. On the issue of inducement, Mr. Martin's statement said, I first said, no, I don't want to do that, and then they offered me $100, and, who could turn down $100? That's a lot of money for me. So with regard to every single thing that would establish entrapment, inducement, who made the first approach, was there ever a refusal to do it before the police gave more inducement? On every one of those, Mr. Martin gave answers in his statement that would substantiate an entrapment defense. Reynolds and Gonzalez gave exactly the opposite statements, and the state was allowed to call an expert to tell the jury that Reynolds and Gonzalez was telling the truth. That's why this can't be considered harmless.
Now, what about the state's claim that the defense opened up all of these avenues of character and so forth and so on that the state then went into in great depth?
Right. With regard to the 404B and evidence of predisposition, the state is certainly allowed to put things in. The problem here is, one, there still has to be the McGinnis instruction. We are not saying that they were not allowed to introduce evidence of predisposition. What we're saying is the jury has to be instructed as to how to consider that evidence.